So remember that, after the lecture today, so we are going to talk about the assignment, all right? We're going to talk about our assignment. But we spent around 10 minutes to talk about the assignment. So don't be too excited. You are not going to have the answer, right? No model answer will be delivered to anyone, right? So don't be too excited. Just, in general, talk about the, what kind of answer I look for, right? What kind of answer I expected from you guys. So to avoid any serious mistake, right? But no answer will be given. Okay. Before we start lecture 8, so let's talk about lecture 7 again, right? We spent a few minutes to talk about lecture 7. Right. What we learned in lecture 7. Director. Lecture 7. Lecture 7. What we learned in lecture 7. What we learned in lecture 7. Directors, right? We learned about directors in lecture 7. So any of you remember the definition of director? Definition. So how we define directors? The company ordinance. So how the company ordinance define directors? Is it someone appointed by the board or someone appointed by the general meeting? So how the law define directors? Well, very important concept. Mary, it seems like you know the answer. Statutory position. Yes. Other than that. Manager. Yes, but something even more important. By looking at the function of the directors, he's a manager, of course, right? He manages the company. But how the law define directors? Except for being a statutory position. Someone occupying the positions as director, regardless of the title or the name. So we are looking at the function of the director. So that's why we have a concept that we call shadow director or de facto director. It means that when you claim yourself to be a director and you are actually working as a director, but in law you will be presumed to be a director. Or if you are controlling the other directors, then you will be deemed to be a director. So if you are being deemed by law to be a director, you will be responsible for what? All the liabilities and all the obligations imposed by the company ordinance, all right? So that's a very important concept. And also, directors own fiduciary duty to company or shareholders. Company, not shareholders, right? So don't mix up. Don't mix up. Because they are separate parties. Directors, company, and shareholders, they are all separate. The shareholders own the company, but the shareholders, even the shareholders own 100% of the company. But the shareholders, they are not the company. So as a director, you only own fiduciary duty to the company, right? So very important concept. Anything else? And remember, lastly, right? Chapman's rule, indoor management rules. So it means that, but try to remember that unless we only have one director, right? If we only have one director, then we don't have the board of directors, because there's only one person. But if we have more than one director, it means 2 or, 10 or 20, then we have a board of directors. So if we have a board, then the directors, they make decisions collectively, right? Not one single person. They have to vote. Simple majority, raise their hand, right? But don't mix up the concept of order resolution and special resolution. So order resolution and special resolution is a concept only related to general meeting, the voting by the shareholders. But it's nothing to do with the directors. Because in the board of directors, the shares will be ignored, right? We only count the hands, and we call them simple majority. We don't call it order resolution, right? Okay. So when a board makes decisions, that decision based on, they make decision collectively. So sometimes, as an outsider, you don't really understand what happened inside the board, right? It means that maybe something wrong inside the board. when they made the decisions. Maybe they violated the articles or some procedural errors. But always remember the turbulence rule, or what we call the indoor management rule, because as an outsider, so basically you can ignore all the legal errors inside the board, right? So basically you can ignore, unless you have constructive notice. Unless you have actual notice, right? Actual notice. Actual notice, it means the company actually notified you concerning something wrong inside the board. So otherwise, right? Otherwise, you can ignore the internal management of the company. And you can assume that everything inside the company is fine, is perfectly okay, right? And it means that your contract will be binding to the company. But don't mix up this concept with object course, because the object course only related to object course. But the indoor management rule include everything inside the board, right? Any kind of error inside the board, right? They are different concepts, okay? So that's what we learned in lecture 7. So today we are going to discuss a very important concept, right, in lecture 8. So you have to be careful, right? You have to be careful. So think about lecture 6 and lecture 7 again. In lecture 6, we learned about shares capital. It means we learned about shareholders and the general meeting. So we know that the shareholders, they vote by passing resolution in order to manage the company. And in lecture 7, we learned about directors. We know that the directors, they are managers. So they manage the company directly, right? And they are the most important organs in the company. Board of directors and shareholders. We look at the first paragraph. I hope that you remember, right? And you should always bear in mind the two organs in managing the company, right? All right, so it seems that everything is fine because we have the board of directors. So when they want to make decisions, they vote, right? By showing their hands. They have they hold a meeting. They hold a conference in the board. And for the shareholders, they vote again. And we have the rules here. Ordinary resolution, special resolutions. So it seems like we are living in a wonderland, right? So everything is so happy because we have a system. Right? We have a system that functioning smoothly. Everything seems to be okay. But no, because we are not living in a wonderland. We are not living in a utopian world, right? We are living in a very cruel commercial world. So sometimes we have troubles. So I suppose that you understand the function of board of directors and the members' general meeting, right? The problem may arise because the inherent decision-making mechanism of the two organs cannot resolve some of the dilemmas within the company. So it means that even we have the board here, right? The board makes decision by voting. And we have the general meeting here, and they vote again. Democracy, right? We vote, we discuss, and then we make decision on something. So it seems like everything fine, but not entirely. Well, we have problem. Why we have problem? Because sometimes the inherent decision-making mechanism cannot resolve some problem, right? Even the board functioning very well. All the directors, they are willing to comply with the articles, and they're willing to comply with the company ordinance. And we also have the meeting for the members to vote, right? And everyone attended the meeting. So we don't have any problem with the quorum. Well, everyone went to vote. Everyone, try to resolve the problem by discussion, by voting. But because of the limitation of the company mechanism, there's sometimes something that even our board, that even our general meeting functioning perfectly well, but we cannot resolve this kind of problem. it means something cannot be resolved by the company mechanism, because that's inherent problem. What I mean by inherent problem? So that's the design of how this company being functions. But this mechanism cannot resolve some problem, right? Before I explain to you what kind of problem we need to face, before that, think about the two guiding principles in corporate administrations, right? They're the very important guiding principle regarding the management of the company. Well, you already learned about board of directors, right? You learned about general meeting. But underlying the general meeting and underlying the board of directors, there are some principles here. They're the majority rule and the probability rule, right? So let's think about the majority rule first. Majority rule. What I mean by majority rule? So think about the board of directors again, right? So we have 10 directors here. We are having discussions. We are negotiating for something. For example, right? We want to know whether our company should invest $10 million in a new property project in Beijing, right? Okay. So we have 10 directors here. So we want to make decisions. So finally, how do we make decisions? Well, simple. You already learned it. We don't call it resolution in the board. We just what? Vote. Raise your hand. All right. So we have 10 directors here, and maybe I'm the chairman. Right? I'm the chairman, so I propose. Right. So let's vote on it. All right. And raise your hand. Right. Not vote on it. You raise your hand. So all the directors here. So how many of you think that we should invest in the new project? How many of you think that you should not? We should not invest in this new project, right? But what's the underlying principle here? So if we get 6 hands here, out of 10 directors, it means what? It means yes, right? It means the answer is yes. So the board decided that we should invest in a new project in Beijing, right? But the underlying principle is what? So why 6 hands saying yes? Then you can assume that which is equivalent to a company decision. What's the underlying principle?
Majority rule.
More than half, right? More than half, but what it means?
Majority.
Majority, yes. Right? The principle under democracy is what? The minority follow majority. 多少数服从多数. Right? So that's the rule of democracy. So you can further elaborate this principle into a book. But ultimately, right, the most important thing is, the most important guiding principle under the administration of companies, the rule of majority. So it means that, think about the board again. When we have 6 directors, out of 10 saying yes, and then we can assume that that's equivalent to a company decision, right? We agreed on something. We passed it on. Not actually a resolution, right? But we make a decision. But the point is, because 6 out of 10 means majority, right? The majority agreed on something. And then you think about the general meeting. I mean for the members, right? For the members. For the members to vote, right? Now they vote. Because in the general meeting, we count the shares normally. So when we have 50%, so more likely to be safe, 51% will be even better. Because you already understand the concept of deadlock, right? If 50% saying yes, 50% saying no, we only have a deadlock. So if you have 51, you can make sure that you can pass a resolution. And then think about it. When we pass a resolution with 51%, when we pass a special resolution at 75%, what's the underlying principle here? Same as a board, right? What is it? Majority rule. Majority rule. Okay. So we look at the first paragraph. It means that decision of the company should always be made and being decided by the majority, right? No matter in the board or in the general meeting. So in the board, majority means the head counts. You know how many hands, right? Hands you raised. Just head count actually means head count. So in the general meeting it means more shares. But you can always request to vote by poll, right? If you have more shares, then you'll be in control. But think about it, right? Think about it. Well, that's simple, right? Very easy to understand. The rule of majority. But if we have rule of majority, what you can ensure to happen? So I'm sure that if we have the rule of majority, the majority, they are always in control, right? They're always in control. If I hold 75% in the general meeting, I can make sure that just by myself, I can pass all the resolution, right? No matter it's an order resolution or special resolution, right? So under the rule of majority, the major shareholder or the majority, they can always in control. So that's the only thing that we can make sure to happen in the company, right? So any of you ever heard about a legal concept we call corporate governance? 公司管治有冇聽過? If any of you work in a listed company, probably you heard about, but you don't understand, right? But you once heard about. Why we have a concept of corporate governance? So corporate governance is not exactly the same as company law or compliance. It means more than that, right? More than just following the rules. Because if you just follow the rules in the company ordinance, you can only ensure one thing will happen. The majority, they can always be in control. They will always be in control. That's the only thing that we can make sure to happen. But I want to ask you a question. You think about it. Do you think that the majority will always do something good for the company? No. So it means that the rule of majority can only make sure that the decision being made by the majority, the major shareholders, or most of the directors. But it doesn't mean that this rule, right, the rule of majority, can make sure that they make a good decision for the company. Because they are bad guys, right? Also, they are bad guys. So people are selfish. When they are in control, they will use their power. And that's human nature, right? So the rule of majority cannot make sure that the people in control are actually making a fair decision or making a good decision for the company. So that's why even the rule of majority functioning perfectly well inside the company, no matter in the board or the general meeting, but it can only ensure the majority in control, but it cannot make sure that the decision being fair and good to the company. Do you get my point? And that's a very important concept here. You look at the last paragraph. The problem with this principle is that the majority, they can easily abuse their power in the general meeting or in the board. Because when I'm the majority, okay, let's vote on it. So I'm always the winner, right? I don't worry about how you try to challenge my decision in the board or in the general meeting, because I know that I'm the majority, right? I represent the majority. So I'm always the winner, and you will always be the loser. Even I'm doing something bad, but you cannot stop me. Right? Think about it. Is it right? Absolutely. So they can manage a company in a way that only benefit themselves at the expense of the company or the minority. Right? So that's the first problem you have to think about. So how about a second problem? Something we call the propagative rule. So any of you still remember the status of a company. So how we describe a company? From the Solomon case. What we learned from Solomon case? What we learned from Solomon case? 唔記得咗啊 俾一面好 Okay, so any of you still remember Solomon case? The most important thing we learned from Solomon case, not shoes making, of course, right? What we learned, separate legal entity, right? Separate legal entity, right? So it means that, right? It means that a company itself is an independent legal person once being incorporated. So once you establish the company becomes a legal person, independent from the owners, independent from the shareholders, right? Independent from the directors, entirely separate. So you can sign a contract, even you are the owner, right? You can sign a contract with the company. So that's the most important concept we learned from the Solomon case, right? Okay. So you know that. You will know that. You can fully understand that a company is a separate legal person. So if something wrong being done to the company, who is the one to suffer? Legally speaking.
The company.
The company, right? So the company is the victim. Some bad guys, some bad guys, they've done something bad to the company. So who's the victim? The company is the victim, right? The company is the one who suffers from all the wrongful behaviors. So if the company is the one to suffer, then who's the one to sue the bad guy? Company, of course, right? Because the company is the one to suffer, not the shareholders. Well, you suffer indirectly as the shareholders because you hold the shares, right? The shares means your investment. You learned in lecture 6. Say, like, if the company is losing money, then the value of the shares will diminish. So you will also suffer, but indirectly. But think about the Solomon case again. If something bad happened to the company itself is the victim. So if the company is the victim, then the company is the one to sue. Is it correct? It's logical, right? It's logical. And that's perfectly compatible with the Solomon case, right? With the Solomon case. But I want to ask you a question. Because a legal person is only, a separate legal person is only a legal concept, right? It's only a legal concept. But sometimes we call it legal fiction. With the company, it doesn't exist physically, right? It's only a legal concept. Physically, the company is only a box file, right? A box with some documents here. So it's only a legal fiction, a concept in our mind. So a company must be represented by someone, right? So in real world, the directors, they control the daily management of the company, right? So if the company want to sue someone, so who is the one actually making the decision? Directors, right? Directors. And directors make decisions collectively based on the principle of simple majority. It means the major number of the the directors, they will be the one to make the final decision, whether to sue someone or not, right? For example, if there are 10 directors here, then if 6 directors or more than 6 directors, they decide to do something, and that will be the final decision of the company, right? You understand that concept? But how about if the majority of the directors, they are in fact the bad guys? You get my point here, right? So 6 out of 10 of the inside the board of directors, they are actually the wrongdoers, and they are the bad person. So they are the ones, trying to harm the company, right? Trying to steal the money from the company, or they are trying to do something which is oppressive to the minority. Then do you think that they will procure the company to sue themselves? Then you get my point here. And we have a dilemma. Because we have a rule that we call the public plaintiff rule. It means that when a company suffers from something, when a company is the victim of some wrongdoing, right? Then the company should be the one to sue on it. And not shareholders, not directors. But you have to think about it. What happened to the bad guys? They are actually in control of the company. Then of course they will not procure the company to sue themselves. becomes a dilemma, right? And that's what we call the public plaintiff rule. It means that if anyone, they have done anything wrong to the company shall be the one ensuing the wrongdoing. And that's what we call the public plaintiff rule. And this rule is based on a case we call force and Harbottle. What happened in this case? Very simple, right? But the principle, the legal principle underlying it is what really important. The two shareholders want to sue the directors for the misapplication of the company asset, right? Some shareholders want to sue the directors because they misused the company asset. But the court held that the company is the one who suffered. The company is the one to sue to be the plaintiff and to sue, not you, right? Not shareholders. It's because the company is an independent legal person and shall be the proper plaintiff should be the proper plaintiff to sue for his own right. And that's what we call the proper plaintiff rule here. And then you think about it in the last paragraph. The problem is that those who harm the company may also be the one in control of the company. It becomes impossible for the company to redress the wrong, right? So think about that. We have two problems here. Number one, majority rule. Because of the majority rule, the majority, they can always control the company. But it cannot make sure that they make good decisions for the company. They can make bad decisions. Decisions only benefit themselves at the expense of the company, at the expense of the minority. And based on the company's own mechanism, this problem cannot be resolved. Because when you vote, the bad guys, they can always be the winner, right? And then you think about the public plaintiff rule. When the company suffers for something, only the company can sue. But the bad guys are in control. So you know that the company will never sue the bad guy, right? Because the company actually being controlled by the bad guys, all right? How do we solve the problem here? How do we solve the problem? So we have a very good legal system. So the legislator or the judges, they recognize this problem and they try to, solve the problem. How do we solve the problem? Do you understand the problem here, right? So how do we solve the problems here? The law, right? The company law provides certain remedies to address, the problem we just mentioned. So we have some remedies, and they are very important, particularly important for the minority. Why it's so important to the minority? If you are the majority, I don't think you have to worry about it. Because if you are the majority, right? You don't have to worry about it. If you are the majority, you are always in control of the company. You can rely on the company's own mechanism, but not the remedies here. It means the law provides certain remedies, some help, assistance to the minority to solve the problem, right? To fight the bad directors or the bad shareholders where they are in control. So if you are a minority, all these remedies will be very important to you because you are being hampered by your own positions. But if you are a majority, you don't have to worry about it. You can still rely on the company mechanism, right? You can resolve the problem. You can pass a board resolution to kick someone out, to stop to do something, or to do something. Or if you are in control of the general meeting, you pass all the resolution. Do you remember how to remove director? Because the company law states that if you can pass all the resolution, you can always remove a director, right? Regardless of anything in the articles, and regardless of anything in the shareholders' agreement. So you can always remove director. So you don't have to worry about all the remedies here, right? If you are the one in control. But if you are not the one in control, it means you are minority. You hold less than 50% in the shareholders meeting. Or if you are the minority in the board of directors, then you have to think about the remedies in the company law in order to help you to fight the bad guys. All right? So what are the remedies available? we have three. Number one, statutory derived actions, unfair prejudice application, and winding up on just and equitable grounds. Right? We have three different remedies available for the minority to fight the bad guys. Right? So which one will be suitable to your case? Right? The first question to ask is, you learn about all the remedies here. Right? You are the one sufferer because you are in a minority. So you are not suffering from something. So you try to seek for help from the court. And later on you are going to learn about when you want to initiate a civil actions, you need to have a cause of action. Right? So legal term means a cause of action means a reason accepted by the court that you have the right to initiate legal action, right? Cause of action. For example, that can be breach of contract, right? That can be breach of contract. If someone sign a contract with you, you pay the money and you don't get the goods, then you can sue. And the cause of action for you is breach of contract, right? That is a reason accepted by the court that you can initiate legal action, right? Or you are a civil servant, you are being suffered from some wrongful decisions of the government, right? To fire you, to dismiss you from your position, then you can apply for judicial review, and your reason is unfair dismissal. And unfair dismissal is the cause of action, right? This is what we call cause of action. So you have to think about it. If you want to know which remedies applicable to your case, you have to think about your cause of action. How you're being suffered, or what actually being happened to you, right? I will explain to you in details on each of them, right? So don't worry. But the first question, the first thing you have to consider is which one will be applicable to your case. The first question to ask, you have to choose the most appropriate action, whether that is the derived actions, whether there's an unfair prejudice application, or a widening of proceedings. The choice, right, for the most appropriate action shall depend on whether the wrong being done to the company or to the member personally. The students or the lay person or for anyone studying law for the first time, they always make a mistake. Because they don't know if something wrong happened. So that wrong thing actually harm the company or harm the members. Because that's entirely different. You get my point here, right? Because the bad guys are in control. The shareholders, they hold 75% of the shares, so they control the general meeting, right? They control the general meeting. They are also having the majority numbers in the board of directors. They are also in control of the board of directors, right? So they are doing something bad. And you are the minor shareholders. You cannot, fight the bad guys within the company mechanism, right? So you try to seek help from the court, and you learn about all the remedies. So you learn about all the remedies. But the first question to ask, which one will be suitable to your case? And you have to think about that. That wrong thing happened. Is it a wrong thing done to the company or bad thing, harm the interest of the shareholders, right? Because that's different. And you have to be careful. I'll give you some examples here. So if the directors, they misuse the cash in the company's bank account, is it a harm being done to the company or to the members? the money belongs to the company. So the director misuse the cash in the bank account to buy something for himself, right? Is it harm being done to the company or to the shareholders? To the company, right? There's a harm done to the company. If the company make a profit of $100, and the board of directors declare dividends, we understand dividends, right? It means your sharing of the profit based on your percentage of shareholders. If the company make a profit of $100, and the board decision decide that, okay, we distribute dividends, you hold 30%, right? You hold 30%, maybe 20%, right? You hold 20%. And the major shareholders hold 80%. So you share $20, and the major shareholder share $80. That would be fair, right? Because your shareholder is 20%. But if the major shareholders, they distribute all the money to themselves, but not to you, right? $100 to the major shareholder, you get 0. Is it a harm done to the company or to the members? To the members, not to the company. Why? Because the profit, the money will be distributed anyway, right? So from the perspective of the company, when $100 being distributed to the major shareholder, or just to the shareholder, or to the shareholder and to the minor shareholders, there will be no difference. Because the $100 will be paid out anyway, right? So that's not a harm to the company. But that is a harm to the minor shareholder. Because I hold 20%, so I suppose I can share 20%. But I have 0, right? You took all the money. So there's a harm being done to the members. So when something wrong happened, bad decision being made by the majority, the first question to ask is it a harm to the company or to the members, right? You have to ask the first questions. So when the copyright being infringed, it means the bad things actually happen to the company. Then you choose the statutory derived action. I'll explain to you what it means, right? But just remember this first. When a bad thing being done to the company, then you choose the first one, statutory derived actions. If bad thing happened to the member, to a member, one member, or to the members, right? Then you choose the second one or the third one. Unfair application, unfair prejudice application, or widening of application, right? Sometimes in the real world, right, in reality, it's possible that something wrong being done to the company and the members at the same time. So I list out all the different things with the bullet points here. So that's only for convenience in learning, right? Because we are in the classroom. But in the real world, in the courtroom, right? Not in the classroom, in the court, everything makes up. So sometimes in real life, bad things can happen to the company and the shareholders at the same time. So if that's the case, how to choose? So that will be a matter of tactics, right? Litigation tactics. So you have to think about that. What kind of evidence being available to you in order to prove your course of action? So it means that, right, even you can sue for derived actions or unfair applications. But you have to think about which one that you have a better chance to succeed in court. You have to think about the evidence, right? Or sometimes you have to think about the litigation tactics. It means which one being most oppressive to your enemy, right? But sometimes when you initiate legal action, you want to put some pressure on the other side. So you have to think about the litigation tactics. But anyway, just remember that in real life, everything can happen at the same time. But for learning purpose, we try to learn one by one, right? that would be easier for you to understand. All right? Just remember, we have 3 different remedies available. One thing being done by the major shareholder, the majorities, right? And how to choose? 1 and 2, the harm being done. Sorry, number 1 being for harm being done to the company. 2 and 3, the harm being done to member or members, right? So let's take a look at the first one, derived actions. Derived actions. What I mean by derived? Sometimes we call derivative. Derivative, what is it? Anyone who work in the financial industry? 又或者金融界嘅 derivative 係咩嚟 ？What's derivative? 衍生工具 right? Yes. Can you help me to define, what I mean by derivative in simple terms? So sometimes, when you want to invest in a share, say like in HSBC, right? You want to buy a share in HSBC because you believe that the share price will go up or go down. You don't have to buy the shares of HSBC actually. You can buy some financial instrument issued by the bank or some other financial institutions, right? So that financial instrument, no matter how you name it, is actually based on the value of HSBC, that you may make a profit or you are losing money. So that instrument is actually derived from HSBC. Itself means nothing. Everything of this financial instrument, right, this thing, is actually derived from HSBC. So what we mean by derived? 中文叫咩？衍生工具 right? It means actually the value or authority is from something else, but not myself, not itself, not myself, right? But from something else, derived from something else. So what we call derived actions? The derived actions is to resolve the problem of the proper plaintiff rule. What's the proper plaintiff rule? What's the proper plaintiff rule? Right, only the company can sue. If bad things happen to the company, only the company can sue, not the members, right? Not the directors, but only the company can sue. But the company actually being controlled by the bad guys, so the company cannot sue. So the law, the company ordinance, offer an authority to someone that you can sue on behalf of the company. You get my point here. You can sue on behalf of the company because the company ordinance allows you to do so. And that's why we call derived actions, because your authority being derived from the company. Your right to sue is not because you have the right to sue, but because you are representing the company, right? Your authority is derived from the company. So we call derived action, right? Derived actions. So what it means? The term derived action refers to a legal proceeding brought by an individual on behalf of a company. Very simple, right? On behalf of a company. So why we need to have the derived actions? Because it's an exception to the proper plaintiff rule, where normally when harm being done to the company itself, so we don't want to sue. So that's the general rule, right? But under derived actions, the court authorizes you to sue on behalf of the company. Then we resolve the problem, right? Because it's been authorized by the law to do so. Then you have the right to do so. And that's why we call derived action. Amendment, all right? So, in fact, we call it statutory derived actions. Not just derived actions, but statutory derived actions. Why? Because actually we are relying on some sections in the company ordinance, which is part 14, division 4 of the company ordinance, right? We don't have to deal with it, by section and section. That would be too complicated at this level, right? If you are studying LP or if you are studying JD or PCM, you have to learn, this concept by looking at the ordinance itself one by one, right? Section by section. But at this level, certificate level, you don't have to. But you have to grasp the concept, right? You have to understand what it means. So why we call statutory derived actions? Number one, because actually we are relying on some section in the company ordinance, right? Statutory, a written law. We are relying on the written law, so we call it statutory derived actions. Number two, because in the old days, we have common law derived action. It means that you can initiate derived actions, not based on certain section in company ordinance, but some legal principles only, right? And that's what we call as a common law derived actions, or derived action under the common law principle. But I can tell you that because now we have the new company ordinance, so after 2014, almost no one initiate common law derived actions because the scope is being too narrow. Right? The scope is being too narrow. If you want to initiate common law derived actions, it only covers some wrong things, right? Only something wrong that related to illegal conduct or fraud, right? But under the new company ordinance, under Part 14, Division 4, the written law almost covers everything, right? So that will be much easier for the applicant to sue the wrong guys under the new company ordinance. So nowadays, we only need to concern about the statutory derived action, right? We can almost forget the common law derived actions. It's no longer important, right? No longer important. I just want you to know the name here, right? You just need to learn the name. But you don't have to worry about it too much because 99.9% of the applicants nowadays in court, they only initiate statutory derived actions. So what we need to know regarding statutory derived actions, two things. What can be achieved by the SDA means statutory derived action, right? Statutory derived action. The abbreviation, the subform. Number one, what can be achieved if you want to initiate statutory derived actions? What you can do, right? What can be achieved if you initiate this legal proceeding? Number two, so how to obtain the grant from court to initiate the legal proceeding? Of course, you have to make sure that the court is willing to grant you the order, because that's not easy. Why that's not easy? You have to bear in mind, normally the court will not do anything against the mechanism of the company, but you have a mechanism here. If you want to bypass the company mechanism, unless you can only ask the court to do something like this if you have very solid evidence. Just like the concept of judicial review, right? If you are being fired by your supervisor, if you are a civil servant, right? If you are being fired by the commissioners or your boss, right? Or you are being fired by a chief executive, because that's the normal rules. So we have the right to fire the staff, the supervisor. So that's the normal rule, right? Normal rules. So normally the court will not, the court, they are not interested to interfere your decision, because that's what generally happens, right? So if you want to overrule the decision from your supervisor that you are being dismissed unfairly, then you need to have very solid evidence to persuade the court to grant an order. Because normally they are very reluctant to do so, because that's the general mechanism. So how a department works, how a company works, right? Who can fire you? Of course, the supervisor, right? Not the receptionist to fire the manager. The CEO, the chief executive to fire the different staff, the civil servant, right? But this is only general rule. This is how our world operates, right? So unless you have very solid evidence, and that's the case, that's very similar to our situation, because normally when you have the board of directors and when you have the general meeting, then the shareholders can vote, and you try to ask the court to overrule their decision, right? You can do so, but that will be very difficult unless you have solid evidence. You need to pass some tests imposed by the law if you want the court to overrule decisions being made under the company mechanism, right? So what we need to learn about the statutory derived action, you have to know what you can achieve by the SDA and how to get the grant from the court to make such an order. Okay, what you can do, number one. What you can do, under section 732, right? So that's the section to deal with the statutory derived action, right? So you don't have to look at it directly. That will be too complicated. Right? That will be too complicated. You don't have to. If you want to, you can, of course, right? You can search in the internet to look at the statute itself, right? The section itself, but I don't think you have to. But we have to understand what can be achieved if you initiate the SDA, the statutory derived action. What you can achieve? The law states that by bringing the statutory derived actions, you can bring a legal proceeding. It means to sue someone, right? Bringing proceeding, it means to sue someone on behalf of the company. If the company cannot do it by itself, number one. Number two, to step in any legal proceeding on behalf of the company, if the company cannot handle such proceeding properly. Two things, right? Two things that you can try to achieve by initiating SDA. Listen to it once again. Listen to it once again. You can bring a proceeding on behalf of the company, right? You have the right to do so. If the company cannot do it by itself, the company cannot do something. If you initiate the SDA, then you have the right to do that thing on behalf of the company, number one. Number two, the company already initiated the legal proceeding already, right? But the company is not handling that legal proceeding properly. Then you can initiate SDA to step in that legal proceeding, right? All right? I'll give you some example. Then probably you can understand. But you have to understand what we can achieve by initiating the statutory derived actions. We look at an example here, number one. Example one. For example, right? For example, there are 5 directors in the company. So and 3 of them misappropriate the asset of the company. Right? They misuse the asset of the company. 3 of them. 3 out of 5 means what? Majority. And they are controlling, right? They're controlling the board. So it means their decision is the decision of the company. So a member proposed to initiate legal proceeding against them, but all kinds of legal action has been denied in the board by the involved directors. But that can happen, right? Because the bad guys, they are in control. So even one member, finds something wrong regarding the use of the company asset, and he tried to do something, but the board of directors will always deny everything. Why? Because they are in control, right? So if something happened like this, then you can initiate statutory derived action, all right? And you can represent the company to bypass the board. You represent the company as a member. Represent the company to sue the 3 bad directors here. And that is, example 1 is this one, all right? Do you understand? And we look at the second example. So the director stole $1 million from the company bank account. But we ignore the criminal issue first, right? Because it's more criminal issue, but we ignore that first. We focus on the civil law, right? We only focus on company law. Because actually there's a criminal offense, and based on quite long, right? Well, we just ignore criminal law first. Suppose there's only a civil case. So a director stole $1 million from the bank account of the company. The other directors learn about it, right? The other director learn about it and decide to sue him on behalf of the company. All right, this time is better because some directors are willing to take action. I mean, to sue, initiate the company to sue the bad director, right? So the company is actually taking action. But you can still initiate the SDA. Why? Because the majority of the directors are good fan of the bad director, right? Good fan. and they only decide to sue him for what? 100,000. There's only 10% of the money being sold by the of the bad director. So what happened in this case? In this case, the company did not initiate any legal proceeding at all, right? The company has done nothing. In this case, the company initiated legal action, but what? Not publicly. But the company should sue for $1 million. The company only sue for 100,000. Only 10% out of your losses. So the company is not handling the case publicly because the bad guy still want to cover another bad guy, right? So in that situation, you can also initiate statutory derived action. And the example 2 actually referring to the second point, right? To step in any legal proceeding on behalf of the company, if the company cannot handle such proceeding publicly, all right? So very important. A little bit complicated, but try to understand, right? Try to understand. The meaning of misconduct. So we have to understand what it means by misconduct. Why so important? You look at the point I list out again. Look right here. Right? Look at point number 1 and point number 2 again. So both point number 1 and point number 2 rely on one single concept. What is it? To bring a legal proceeding on behalf of the company cannot do it by itself because of a misconduct committed against it, right? The second one, to step in any legal proceeding on behalf of the company, if the company cannot handle such proceeding properly because of a misconduct. So misconduct is a key concept here, right? So it means that, right? It means that even sometimes a legal action not being negotiated by the company, not being initiated by the company, right? Sometimes. Or sometimes a legal action not being handled properly. But if that's not related to a misconduct, then you cannot initiate statutory derived action, right? It means well, you can only initiate statutory derived actions under reason here and under reason here only because of a misconduct. If that is not a misconduct, then you cannot initiate statutory derived action. For example, if that happened only because of what? Negligence or careless of the directors, then you cannot initiate statutory derived action. We have other sections in the company ordinance to deal with this kind of scenario. Something we learned in a previous lecture. Do you remember that as a director, you need to perform your duty up to a certain level of competence? Do you remember? I draw a diagram here. I try to write the different lines here, right? As a director at HSBC, your lines will be here. The bottom line will be here. As a director of ABC Limited, the bottom line will be here. And if you're an accountant, and if you're a lawyer, the bottom line will be raised further and further, right? Because as a director, you have to perform your duties to a certain level of competence, right? So if someone not taking legal action, if the board of directors not taking legal action because they are stupid, right? Because they are only foolish, stupid, or careless, right? Just careless, 蠢, right? Stupid. They know nothing about law, right? They don't have good business sense. You cannot initiate statutory derived action because that's not from misconduct properly. Properly, right? Properly. Depends on the level of negligence, right? I can tell you. Actually, depends on the level of negligence. If that's so serious, right? So serious, then that may also be regarded by the law as misconduct, right? I know that's very contradictory, but you have to try to understand because there are always gray areas. But just, as a general rule, if someone's not taking a legal action because they're foolish, right? They're foolish. They're stupid, right? Then probably you cannot initiate statutory derived action. Right? Negligence, maybe not appropriate, right? Forget about negligence. Foolish, right? Because they're foolish, because they're stupid. Then they cannot, you cannot. Or because they are not on good terms, right? Because they hate each other, the directors. So they do nothing. And that's probably not misconduct, right? That's something else. So we have to understand what we mean by misconduct. Because it includes negligence, right? So forget about negligence, not negligence, right? Careless, right? Just careless or foolish. So how to define misconduct? We have to understand what we mean by misconduct. Because only when someone is not taking legal actions. So based on something within the definition of misconduct, so only in that kind of scenario that you can initiate statutory derived actions. So the law defines misconduct as fraud, negligence, very serious negligence. Breach of duty or defiant compliance with any ordinance or the rule of law actually cover almost everything, right? It covers almost everything. So the definition covers a wide range of wrongful affairs, with the exception of careless, irresponsibility of illegal activities. So almost everything. But anyway, if you want to initiate statutory derived action, still you have to prove misconduct, right? You have to prove misconduct. And that's one thing that's very good. The misconduct can be commenced by any person against the company, but not just the majority. For example, in this case, right, leave was granted by the court to bring legal proceeding against the company former solicitor. But that's very nice. So it means that, right? It means that when you initiate the statutory derived actions, so normally you sue the majority. Normally, because the majority, normally they're the bad guys. They are in control of the company, and they try to do something back to the minority and to the company. So normally you sue the majority. But under statutory derived action, actually you have the right to sue anyone. For example, in this case, because the solicitor held the majority in doing bad things, so you can also sue the solicitor of the lawyer of the majority, not just the majority, right? So it covers very wide areas, and there's always subject to the discretion of the court, right? So you learn about the first thing, that is first thing we need to know. We just discussed it. What can be achieved by the SDA, right? Now we deal with the second one. How to get the grant from the court to initiate the legal proceeding, right? How to persuade the court to grant you the order. So we have to understand the first whole in granting the application, right? We call it the leave of the court. It means permission for the court to grant the order. So something will be considered by the court under the company ordinance. Number one, it must be in the interest of the company. Number two, it must be a very serious question. Number three, this one is easy to understand. When the company is not itself pursuing an application, of course, right? Of course. Otherwise, you don't have to initiate the legal proceeding, right? Otherwise, you don't have to. And the written notice being served to the company for 14 days prior to the application. So I explain to you one by one, right? One by one. So it means that you have to fulfill all the application, so all the requirements before the court to grant you the order, right? So you have to make sure that your case actually fulfill all the requirements here. Number one, interest. So you have to prove that if you initiate the statutory derived action, that's for the interest of the company. What kind of interest? And you have to ask. In regard to one fact, commercial interest. Well, very important, right? Very important, commercial interest. What do you mean by commercial interest? Normally means
Money. Money.
money, right? Correct. You have to think about it from the financial perspective, right? Commercial interest. So you cannot fight for some, abstract legal principle. You cannot fight for environmental protection, right? You cannot fight for any charitable purpose. No. The court will only grant you the orders if that concerns the commercial interest of the company, right? Not environmental protection, right? No. Not enough, right? That will not be considered by the court. The first one is not really hard, right? It's not really hard. You only need to have a prima facie case. Prima facie case is a legal term, means preliminary, 表面上得㗎啦, right? And it's not necessary to be a cause and benefit analysis. You don't have to prove a formula or equations to the court in saying that if we initiate the statutory derived action, then we can save $5 million. If you don't grant me the court order, right, and the company is going to lose $3 million, you don't have to show a calculation here, right? Because it is not necessary to be a cost and benefit analysis. Just as, by using your common sense, if I can get a court order, and that will be good to the company, regarding commercial interest, and that will be fine, right? That will be positive financially to the company. That will be fine. You don't have to do the math, right? You don't have to prove to the court that by having the order, then the company can save $2 million or $1 million. You don't have to, right? You don't have to find an accountant to submit a report for cost and benefit analysis. You don't have to, right? Just a general sense when that's related to commercial interest. Number two, it must be something serious. Why? Simple. Simon, you told me that commercial interest means money, right? Yes. Is it $1 is money?
Yes.
Yes. Do you think that you can initiate statutory derived actions? Because that thing, right, concern $1 on nonsense, $10 nonsense, 100 nonsense, right? But I don't know, if you keep raising a number, one day you can raise the threshold. I cannot give you that number, right? But normally, if that sum of money involved in being, neglectable, trivial, maybe it cannot. One of the very important principle is that if it cannot even justify the legal cost, then that will be nonsense, right? To do something. You get a compensation, but compensation cannot pay your legal fees. Then why you do that, right? Fight for justice, forget it, right? No justice in commercial world. We only know money, right? So number three is self-explanatory. It means that number three, right? You know that number three, yeah. When the company is not doing it by itself, right? Of course, right? Otherwise, we don't need to have derived actions. Number four, a written notice for 14 days prior to the application. But this is something important. You're going to learn about later in civil procedure, right? You're going to study civil procedure later. You see in this module, or you have to proceed to the advanced diploma, right? You only need to learn about law obligation. So you don't have to learn civil procedure in this program. You don't have to. See, one day you proceed to the diploma of legal studies, and you have to learn about civil procedure. That's very important. But even you know company law, you know contract law, but you don't know the procedure, still you don't know how to sue your enemy, right? Even you understand criminal law, but you don't understand criminal procedure, then you don't know what happened. You one day you're being arrested, right? You don't know what happened next. It's not enough just to know the law, you have to know the procedure, right? So procedure is something important, but I can tell you a little bit about civil procedure. If you want to sue someone with a civil action, right? So one thing you have to do, you have to, it means you don't have a choice, right? You have to means you don't have a choice. You have to serve a demand letter to the bad guy you want to sue, right? Do I want to sue Angela? Because I want to sue you for breach of contract, right? You owe me $1 million. I sign a contract with you, I deliver all the goods to you, but I don't get that payment. So I want to sue you for breach of contract for $1 million. But before I file all the documents to the court, right? So I have to do one thing, and that is the demand letter. I have to. So if I fail to serve the demand letter, my application to court will be struck out by Angela. It means that action will be stopped. right? You fail all the legal actions, but just to serve one letter, and that's the demand letter. 即係英中文叫做 decision, right? Demand letter means what? You ask for something, right? Demand letter. I hereby instruct my solicitor. You are going to get letters like this, right? If a letter issued by a law firm, right? Everton and Co. And we hereby represent Everton, right? To sue you, we intend to sue you for a breach of contract that you have to pay my client $1 million within the coming 14 days. You always like that, right? You have to pay my client within the coming 14 days. Otherwise, we will initiate legal actions without further notice. Right? 一定係咁 right? Without further notice. But they have to warn you for the payment. So you are not paying the sum I'm claiming for, then I can sue you without further notice. It means no another demand letter, right? Next thing you receive will be a court document, right? So why have to do it? Why I cannot sue you in court directly? You can defend. You can defend in court. You don't have to defend in my demand letter. So the demand letter is not for you to defend. It's for you to respond. So why we always need to serve the demand letter first. If you don't serve the demand letter, your application to court will fail. It's very simple. It's just one letter. 通常2000蚊到啦 2 or 3,000. It's just one piece of paper, right? You think about the solicitor, they are very high. You think about why that letter is so important.
To notify Angela.
To notify Angela, but why I don't notify Angela by court document? I can still notify Angela by court document, right? You're going to have a statement of claim from court. If one day I really sue you in court, and you have to attend the trial, and you get something we call a statement of claim, right? Or writ, go appeal.
Giving her a chance to try to solve the problem.
Exactly. Very good answer. Exactly. Perfectly correct. All right. This to what? Avoid unnecessary costs involved in the legal action. Well, there's a warning, right? To warn you first. Why? Because maybe interest is willing to pay. Why I have to waste my money to instruct a lawyer? Because when you drop that document, you have to instruct the lawyer to drop the statement of claim and the writ, right? Because the layman, you don't know how to do, fulfill all the formalities. You don't know how to drop that document, so you have to instruct a lawyer. So that cost will be involved, right? But maybe I'm stupid, because Angela is actually willing to pay me. So why don't you send a letter to Angela first to warn her that I'm going to sue you, right? Then I can avoid unnecessary costs. Maybe, right? Maybe I can avoid unnecessary costs because maybe Angela is actually willing to pay me. If she learned that, I will take legal action, right? Then I can save the money to instruct the lawyer to drop all the documents because I only need to spend $2,000 or $3,000 for one letter. All right? So that's what we call the demand letter. And the same principle here, right? The same. So what the last requirement is, you have to serve a notice for 400 prior notice. So that's the, save your money to do something.